I think I think the WTO is very successful in that way, but I do think there are some structures of the WTO that make this successful. The way WTO compliance and what gets Congress to comply and other nations to comply in relatively short order are the sanctions that are able to be levied by others on exporting industries. Right? When Bush, here's an example, when Bush decided to do a variety of things on the steel industry for West Virginia, and he was ruled to be illegal under the WTO. What the European nations were able to do was to impose sanctions on orange growers in Florida, all of these marginal states, which Bush actually needed for his re-election. And so that structure, of course, got the Bush's attention and Congress's attention to change. I don't think that all of our future international delegations are going to have that happy structure of having a way of orienting business to be, in some sense, the informal enforcer of pretty rapid enforcer of international agreements. So I'm not sure, as much as I like the WTO enforcement and how ingenious, in some sense, the informal structure of it is, I'm not sure it is a template for all international delegations in the future.
Can I add one thing actually about the WTO, and it applies to NAFTA too, and it's interesting and it ties back into the federalism issue, but notice that like under WTO or NAFTA, if it's a state law that is putting us in non-compliance, who's responsible for doing that? The president can bring suit against the state and get a court order compelling the state to comply with, you know, the decision of whatever it is, right? But if it is a federal law that is putting us in non-compliance, you need Congress, right? So it actually gives the president in the courts a significant role in enforcing these against the states. But if it's a federal law, you got to go back to Congress and get Congress to change the law, right?
Yeah, no, and I think that's, I mean, to me that's a decent template, but maybe for the reasons John suggested, maybe not sufficiently effective template. But it seems like a fruitful template for future international cooperation. And we could have consensus on that, I think, where there might be some consensus on that going forward. All right, let me open this up now to questions from the audience. We've kind of plumbed some of these issues, but I would love to hear from you guys.
Question for Professor Sloss. So I'm sure you're referring to, you know, a very broad debate, but I just thought maybe you could sort of come in a little bit and explain sort of. I take it your position was that non-self-executing treaties are not constitutional, except in cases where they require. I mean, I'm not even sure what this other category was, but if you could kind of explain where that's coming from, where the exception's coming from, why an intent to make a non-self-executing treaty, you made some reference to that at the end before, why that'd be unconstitutional?
It depends what you mean by non-self-executing is part of the problem, because the term is means different things in different contexts, right? But the understanding that I maintain prevailed actually from the founding up until the 1960s was that there are two categories of non-self-executing treaties. One is a treaty that obligates the United States to take steps that fall within the scope of Congress's exclusive powers under Article 1. That is, for example, a treaty that obligates us to appropriate funds, right? If it obligates us to appropriate funds, only Congress can do that because the Constitution gives that power to Congress, right? Second category of non-self-executing treaties is treaties that could be implemented by the executive but not by the courts because they're basically too vague, right? They leave out rule, they lay down some kind of obligation, but it's so hard to figure out what the obligation is that we have this sense of it's beyond the bounds of judicial discretion to take that and sort of try and apply it. So you had a bunch of litigation starting in the 1950s where people wanted to get the courts to enforce the human rights provisions of the UN Charter. But what do the human rights provisions of the UN Charter say? They say take steps to promote human rights, right? And people are trying to get the courts to rule on that basis. Well, this particular California law, which says this is, is invalid because it conflicts with the treaty. And the courts, I think, rightly said, look, that's not our job. We can't take this vague general language, promote human rights, and translate that into a specific rule that, and use that to invalidate a California law, right? Notice that neither of these have anything to do with the treaty maker's intent about the domestic effects of treaties, right? The first is a matter of constitutional limits on parties other than Congress, or where certain powers fall exclusively to Congress, right? The second is about limits on courts that have to do with the sort of nature of the judicial function. But neither of these ideas or doctrines hinge on what did the treaty makers intend about domestic implementation at the time they adopted the treaty. That idea came along really in the 1960s, and it was a novel idea that the treaty makers actually can make this choice, right, about implementation. What's the choice? So what is the choice we think they're making when they say a treaty is non-self-executing? Well, if you take a narrow view of that, I actually don't have a problem with it. The narrow view is it imposes some limits on judicial enforcement, but it doesn't bar judicial enforcement altogether. That's consistent with what Congress does in a lot of statutes, right? The bigger problem is this, that the way a lot of people read these non-self-executing declarations is we're undertaking a binding international legal obligation, right, that we will comply with this treaty, whatever the treaty says, right? So we undertake a binding obligation, we will comply with the treaty. There are constitutional provisions out there that require the president to carry that out under Article 2, require state courts to carry that out under Article 6. And if you read that declaration to override Article 2 and Article 6, I think you've got a problem. You can't have a declaration by the Senate saying the president shall not declare that this treaty is executed. You cannot have a declaration by the Senate saying state courts are not bound. Now, there are a lot of cases where state courts aren't bound, because they don't have jurisdiction over the case. That's another issue, right? But I don't see that a declaration can basically override the provision in the Constitution that says state courts are bound to apply this. So if there's a case where state court actually has jurisdiction, you have a treaty that applies to the case, somebody's saying the treaty requires this outcome and state law requires a different outcome, that is precisely the situation that the Supremacy Clause addresses, and it gives the courts a constitutional duty to apply the treaty, and I don't think you can opt out of that through a non-self-executing declaration.
Sure. I warned you about the self-execution thing. He knows more about it than we've forgotten.
So the basic premise of the response is that the treaty people can't override the Constitution, but you might alternatively think of it as not overriding the Constitution, but just making a different content for the treaty. So if the treaty says, look, our obligation is to enforce this and it shall be enforced by congressional legislation, then there's no violation of the treaty. The treaty itself limits itself. So I mean, it begs the question to say you're overriding the Constitution.
Okay, so I don't want to go into too much of a back and forth here, but the treaty says what the international obligation is. The treaty doesn't say who carries that out domestically. And specifically, the treaty doesn't prohibit particular domestic actors from carrying out the treaty. No treaty has ever done that, okay? We have never had a treaty that actually says, you must do X, but so-and-so may not do X, right? You must do X, but this particular actor in the domestic legal system may not do that, right? So, no, there has never actually been a treaty where there is a conflict between what the treaty says and what the Supremacy Clause says, although there are lots of judicial decisions who think that that's what's going on, but insofar as they interpret the treaty that way, they're simply wrong. It's not what the treaty says.
So I don't want to, it's a quick point. So basically what you're saying is that if they put it in the treaty, if you think that's okay, that would be okay. It's different that they do these reservations that are not part of the treaty.
Right, but the problem is that when you're, particularly in the multilateral context, is you've got the French system where all treaties have domestic effect if they're published. The British, no treaty has domestic effect unless Parliament implements it. So as a practical matter, you're not going to be able to get that text into the negotiation in any multilateral context because the domestic systems are so different. And that was a point that was raised in Medellin, for example, is when the court says you got to look to the treaty for the intent of whether or not it's supposed to have direct domestic effect. That seems to be counterintuitive because there's such a variety of national systems on that question of how they effectuate treaties.
And the background rule of international law that is understood by all treaty negotiators is that the question of who within the domestic legal system executes the treaty is a question of domestic law, not a question of international law, and therefore it's not something that's subject to negotiation among the parties. Now, you can find a couple of exceptions in bilateral treaties where there's sort of specific negotiations. You can't find any exception in multilateral treaties. It's just they don't do it.
Maybe we should. I want to say something, but I won't. Any other questions? Or we can. We're almost done. I think we're done with. Maybe we'll just close up then and thank our. I told you we'd get back to self-execution. I guess I made us do that. But I think it is at the core of this. Thank you very much. Thank our panelists very much.
Thank you.